So today we're going to talk about Module C from the book. It's on page 635, so towards the back, and it's the legal liability portion of the textbook, and most of the standards in here apply to all CPAs, but we're going to really stress what is super important for auditors, and that's independence. And I think a really awesome thing for you to kind of memorize and learn for exams and really understand is page 655 out of the book, because it really talks about the auditor's summary of liability, and so we're going to cover independence and what auditors need to do to be independent, and when people do sue an auditor, what are their defenses, and that's what 655 is. So it doesn't have as much to do with independence as if they've done something wrong. So there's auditor independence and auditor's negligence or fraud, and those are the two main topics we're going to follow, although a lot of the chapter talks about some other liability issues, but we're sticking with those main things. So understand independence really well, and understand this table, Exhibit C.2 from page 655. And you should be pretty good for any exam or quiz, that's for sure. So let's just start with looking at the parts of the PowerPoint, and of course this PowerPoint, like all of them, out there in Blackboard. Alright, so here's what we got going on. Auditors, clients, and third-party users. So auditors have responsibilities, and if auditors don't live up to their responsibilities, well, they're liable for any damages that occur to people who've relied on them. So auditors are doing an audit. People who rely on them are the client to get that audit done and conduct a good audit, right? So they contract with that client, right? You do that engagement letter, that's the contract. So auditors contract with the client and they audit the client, all right? Then there's third parties who rely on those financial statements, and the reason they trust the financial statements about these people is the auditors have audited them. So if these people are trusting the auditors, and the auditors do something wrong or aren't independent, and then the financial statements aren't trustworthy, well then auditors have a liability to the third party. Auditors contract with the client, so if they don't get that contract right, say they don't do a gas audit or they don't do it on time according to the contract, well now they breach their contract with the client. So this is the legal environment auditors work in, and so if they don't do a good audit, or they commit fraud, I guess hopefully nobody would do that, but sometimes they do. So hopefully everything goes right, but when not, these people, the clients or the third parties relying on the financial statements, like banks, like stockholders, those people can sue the auditors and hold them responsible and collect from the auditors. So that's what we mean by legal liability. All right. So there's two sources for auditor liability. In other words, the law says there's two reasons you can sue auditors. Kind of under common law, which is legal precedent. People have sued auditors in the past and won, and so that means going forward you could win based on that. And statutory liability. So the SEC has instituted some regulations, right? And if you violate an actual law, then you've broken the law and can be held liable according to the law. So common law kind of applies to contracts, and it's just cases that have been decided in the past. And statutory, a statute, that's a law. There's an actual law that says what is supposed to happen. So under common law, right, so common law, in other words, through the years, people have sued auditors and have discovered that this is the way we're going to handle auditor liability. There's two things going on. One is breach of contract, and one is a tort. All right. So breach of contract means you had a contract with an auditor. So we're going to talk strictly about auditors, but in general, anytime you have a contract, if you don't perform the contract, you've breached the contract. So for an auditor, when that engagement letter gets signed, they have said, we will perform a gas compliant audit, and we'll do it on these dates, and we'll have it ready by this certain date. So if the auditor doesn't do any of that, right, doesn't do a good audit, doesn't have it ready on time, they've breached their contract with the client. All right? Tort liability means a party has caused some harm to another party, and so the harmed party gets to sue to get reimbursed for that harm. So what you can think about is things like an auditor did a bad audit, but somebody relied on that audit to buy some stock in a company and then they lost money, right? So they've been harmed, right? A tort could arise from any kind of harm. So you have a duty, right, to drive your car safely, and if you don't, you hit somebody with your car, now that person you hit can sue you, right? That's a tort. Same thing with auditing. Auditors have a duty to do a good audit. And if they don't, the people who are relying on them to do their duty can sue. Now what can happen that can prevent an auditor from doing a good job and thereby allow people to sue is that the auditor can commit ordinary negligence, gross negligence, or fraud. Right? So if the auditor does one of these three things, then they can be sued. If they don't do any of these things, if they do a good job, then there's no reason to sue the auditor. So we'll talk about all of this as we go forward. All right. So common law with clients. You can breach your contract with them, which means you just didn't do what you said you were going to do. Doesn't have anything to do with causing them harm, although you may have, but you breached your contract, therefore you have a liability for them. Or you did that ordinary negligence, gross negligence, or fraud, and you caused them harm. Maybe you did a bad audit, the bank didn't trust the audit, so they didn't get their loan, so they lost the chance to buy the inventory at a good price, and now you're going to have to pay them the difference. Now, just because somebody sues you, right, for breach of contract or tort, doesn't mean they collect the money. So, if you get sued and you go to court as an auditor, the client has to show they actually had a loss. I mean, let's say you breached the contracts. Let's say you promised you would have that audit ready by March 1st. And you didn't have it ready until March 5th. But the bank didn't care. They weren't in any big rush to make the loan. The clients got the inventory at the low price. Everything was fine. So there was no economic loss, right? So the client has to show there was a loss. They have to show that the auditor actually breached the contract or was not careful, didn't do a good job, and the loss was caused by the breach of contract, right? So if a client tries to sue you for breach or for tort, they have to have a loss. You have to have actually breached it or committed that careless act or committed fraud, and that caused it. So if clients can show that, then they can sue you and win. However, if they do sue you as an auditor, you can say, well, we didn't breach the contract. We did a good job, or something else caused the client loss. Yeah, we were a day late in getting the audit to the client, but they had bad credit. That's not why they didn't get the loan. They had bad credit, the bank wouldn't give them a loan. It didn't have anything to do with our audit. Right, so something else, contributory negative, the clients are partially responsible. Right, so they don't always win just because they sue. So clients can sue you, and here's what they must show, and you can defend it. Third parties can sometimes sue. So it depends on who that third party is. So third party means it's not your client, but it's somebody who relied on the financial statement. So like a bank, right? Your client wanted to get a loan from a bank, so they had you audit their financial statements, and you either knew or didn't know they were going to do that. But depending on the type of third party, stockholder, bank, government regulator, whatever, somebody outside of your client, you can have more and less liability depending on who that third party is. Right? So if you think about it, a primary beneficiary known by name to the auditor. So if a client engages you to do an audit for them, and they say, we want you to audit us because we are going to go to Clayburg Bank and try to borrow money from Clayburg Bank. So Clayburg Bank said we need an audit please audit us so we can go to bigger bank. Well, so that's a primary benefit. You know that bank is going to use this, so they're known to be foreseen. Parties who can reasonably be expected to rely on the auditor's work. So, again, a bank, you know they're going to get a loan, but you don't know them by name, right? And foreseeable. Parties whose decisions normally rely on audited financial statements. So you know that if people are going to buy stock in a company, they're going to look at the financial statements. You should have been able to know that. So, do you have duties? And therefore, if you violate your duty, a liability to a common law third party. Generally, if you commit gross negligence and fraud, yeah, they can sue you, right? If you do a really bad audit, you don't pay any attention, or you commit fraud, you're in cahoots with the client or something like that. Yeah, sure, that bank or those stockholders, they can sue you. If you just commit ordinary negligence, yeah, you did a pretty good audit, maybe you forgot to check something, and, you know, depending on the venue, in other words, where you're being sued and who that third party is, you may or may not have negligence. Right, so remember that table is going to be very helpful to you in understanding this. But basically, there's been some cases, and I will never ask you to cite a case, right? So I wouldn't worry about this decided this. But basically, you can have liability for ordinary negligence too. Proof and defenses. So just like with your client, if you've done something that caused a third party a loss, they have to show the loss, they have to show that you did a bad job, that there was a material misstatement and the loss was caused by reliance, and you as auditors can defend it and say, well, you are a third party, you don't get to sue me. So in some states and some venues you could do that. The loss was caused by factors other than the financial statements and the audit. So you're the one who invested that money without even reading the financial statement. So you can't say it was the financial statement, right? You caused, or the audit conducted forget. So you did a good audit, and just because they're suing you doesn't mean you did a bad audit. So here's a little chart that gives you summary for ordinary negligence. You might, depending on which case you're thinking about, because I'm never going to ask you about cases, they have found you have no liability for ordinary negligence, or you do only primary, or you do to foreseen, or you do to foreseeable. So depending on the venue, you could have liability to anybody, but I won't ask you about that. So summary of common law, liability, you're liable to clients for breach and tort, you're liable to third parties. Well, you don't have a contract with third parties, so obviously there's not that, so only tort liability. And you're liable for all gross negligence and fraud, and for ordinary negligence, kind of depends on who's suing you and where it is. Now, there's laws actually on the books, right? So we're going to talk about the laws that the SEC requires us as auditors auditing public companies to do. So there's securities acts that regulate securities trading, right? So we're going to talk about that and whether or not you would be liable. So there's two important acts that have been passed by Congress and signed into law back in the Depression, after they had the Wall Street crash, the big famous crash of '29, which led to the Great Depression. They passed two acts. One was the Securities Act of 1933, and the other one was the Securities Exchange Act of 1934. And so how I remember these, and if you ever did take the CPA exam, you'd have, and the Certified Fraud Examiner, now that I think about it, they had both of these on there. You have to understand the distinctions between these acts, so here's how I remember it. The Securities Act regulates initial public offerings, so the initial offering of a stock. So a new company comes on the market and they want to start selling stock in themselves. It's brand new stock. Nobody's ever bought it before. That is what the Securities Act of 1933 applies to. The SEC Act of 1934 comes later, and that involves the exchange of stock, just like the title suggests. The other one was the Securities Act. This is the Securities Exchange. So obviously it has to have been issued to be exchanged on an exchange. So 33 comes before 34, so that's how I remember it. So in the Securities Act of 1933, which again, all this stuff is summarized on the 655, so that's your go-to chart. Securities Act of 1933 is a little more strict than 1934 Securities Exchange Act, and the reason it's easier to sue an auditor under this act, and the auditor has more liability, is because this is the first offering of that stock. This is an IPO, as they call it, and you have to rely on the auditor. There hasn't really been any experience with the stock. People haven't sold it and traded it and exchanged it. It hasn't been out for a while. It hasn't had several years worth of audits. So people are really heavily relying on auditors for initial public offerings. So the Securities Exchange Act of 33 regulates the securities when they're first issued, an IPO. So you have to file this registration statement. It's called a prospectus, and it's filed with the SEC. And maybe I'll pull one up for you when we meet in class on Friday. Because you're relying so heavily on that prospectus, the S1, as it's called, Form S1, to bring suit against an auditor, all you have to show is you had a loss. So you bought this IPO, and then this misstatement was found out in the stock tank, right? So you have a loss. The financial statement contained a misstatement, and that's it. In other words, the auditors, if you fail to catch a material misstatement, you're liable, as long as there was a loss. If it kept going up, no. So that's it. So you have to do a really good job. So the people who buy that stock in an initial public offering under the Securities Act of 1933 don't have to show that they read the financial statements, don't have to show that they relied on them, or even that the misstatement was the cause of the loss. Just there was a misstatement, you missed it, you're liable. Right? So you needed to you needed to do a good audit. You're responsible for ordinary negligence, gross negligence, and fraud under this statute. Your defenses are, well, no, I did a good audit, or the cause was from some other factor. So basically, you have to be able to prove that you did a good audit. You can have civil liability, so you can get sued. If you actually committed fraud, you could, of course, go to prison for fraud. The Securities Exchange Act from 1934 applies to already trading securities, so not IPOs. So you have a little less of a burden, all right? So this SEC Act of 1934 says that, of course, companies have to file these forms, right? We've looked at them, the 10Ks, the 8Ks. If there's something bad with them, you may be liable. If you audited that 10K and you did a bad job, investors could sue you. To bring suit, investors must show they had an economic loss, there was a misstatement, it was caused by reliance on the financial statement. Right? So before, they didn't have to rely on the financial statement, there just had to be the misstatement under the 33 Act. Auditors were aware it contained a material misstatement. So that's, if you let something get filed that has a misstatement, well, that's gross negligence or fraud. That's a pretty high level of bad. It's not just like, oh, that was a mistake on my part as the auditor. So it kind of goes beyond that. So they have to prove that they relied on those statements, and they have to prove you were aware that you knew they were bad secrets. Hopefully you would never let a bad one go out. So basically, scienter means you knew it. The defense is, well, I didn't know it. I acted in good faith. I was not aware. I did a good audit. These are all stemming from the SEC rules. I'm not going to really ask you about those. These are the specific sections under the Securities Exchange Act. I won't get that detailed. I'll just ask you stuff from Module C. Here's another summary. This is the same. This is basically like Module C's Exhibit C2. So if you want to just print out this page so you can study it, that could be a great idea. Auditor liability has gone up and up over the years, so that's why it's important to understand that. Sarbanes-Oxley has increased it. Other developments in auditor liability. RICO doesn't come in. Basically, I'm not going to ask you about any of this stuff, but understanding Exhibit C2, summary of auditor liabilities, is crucial to you. All right, good luck. I hope you do great on any quizzes or exams. So remember, for Module B, all we really care about is independence, and for Module C, all we really care about is this chart. So make sure you understand that. All right, good luck.